a discussion of Chief Counsel Advice 2021-52018 and its effect on the administration of GRATs. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Travis Hayes, ACTEC Fellow from Naples, Florida. In Chief Counsel Advice 2021-52018, the IRS issued a very surprising ruling about GRATs. The IRS plowed new ground in taking an unprecedented and very harsh position on GRATs. This ruling seems to be contrary to their own regulation. Today, ACTEC Fellows Steve Akers of Dallas, Texas, and Lou Harrison of Chicago, Illinois, will discuss this recently issued IRS ruling. Welcome to Steve and Lou.
Thank you, Travis. In CCA 2021-52018, the donor, who was the founder of a very successful company, transferred shares of the company to a 2-year Grantor Retained Annuity Trust. We refer to that as a GRAT. As is very often done with GRATs, the annuity amounts were specified in terms of a percentage of the initial fair market value of the trust. In determining what that initial fair market value was to determine the annuity payments of each of those 2 years, they used an appraisal that was dated 7 months prior to the time of the transfer into the GRAT. The appraisal actually had been done for a non-qualified deferred compensation plan arrangement. Well, in the meantime, after that appraisal had been done 7 months earlier, the donor began merger discussions with other people about the possibility of buying the company. And he actually had 4 offers in hand at the time that the transfer was made into the GRAT. Even so, they used that 7-month prior appraisal amount. Well, after the transfer into the GRAT, there were some updates on the offers. 6 months later, bottom line, they accepted one of the offers that came in at 3 times the value that was used for the GRAT purpose of determining those annuity amounts. Well, another interesting little fact, right before the closing on the tender offer, the donor also made a transfer into a charitable remainder trust, and for that purpose, used the actual tender offer price for determining the transfer into the charitable remainder trust and therefore the amount of the income tax deduction. Well, 2 issues arose in this Chief Counsel Advice. And keep in mind what a Chief Counsel Advice is. That's just advice from the IRS Chief Counsel, from the attorneys to the agents of a position. It's just an IRS position, an unpublished, unofficial position. 2 issues. The first was that the value should take into consideration a pending merger and the discussions of that. This was very similar to a ruling that we got in 2019 39002, where the IRS took a very similar position of an ongoing merger that you ought to take that into account because a hypothetical buyer would know about that and would do so. And indeed, that part of the Chief Counsel Advice is almost word for word what the 2019 one was, except that in this one, they added the phrase, and thereby cast more than just doubt on the bona fides of the transfer to the GRAT. The CCA went on to say that by analogy to the Atkinson case, which was a charitable remainder annuity trust case, one of the requirements of a charitable remainder annuity trust is that there must be at least 5% annual distributions. Although apparently that GRAT was created appropriately, they never actually made any annuity payments. And so the court concluded that because of this operational failure, no deduction at all was permitted for the GRAT in the Atkinson case. Well, the CCA used that to rationalize that this would not be treated as a qualified annuity interest, and therefore the value of the retained annuities was 0. So the donor made a gift equal to the full value transferred into that GRAT. The conclusion that the CCA, the operational effect of deliberately using an undervalued appraisal is to artificially depress the required annual annuity. Thus, in the present case, The artificial annuity to be paid was 34 cents on the dollar instead of the required amount, allowing the trustee to hold back tens of millions of dollars. The cascading effect produced a windfall to the remainderment. Accordingly, because of this operational failure, donor did not retain a qualified annuity interest under Section 2702. I understand the IRS's reaction. One of the features we like best about GRATs is that the regulations tell us we can have this, quote, savings feature in it. We can say the annuity amount is a percentage of the finally determined gift tax value. So if it's finally determined to be a different value, it just automatically adjusts the annuity amount, and the remainder value may go from $10 to $11. It's just wonderful. But the IRS concern is for cheaters, unscrupulous taxpayers. I think they're concerned with defined value clauses generally, that someone would use just an outrageously, unreasonably low appraisal. If they don't get caught, they got by with it. If they do get caught, they just adjust it and life goes on. And so the IRS in this took the totally unprecedented position. They've never done this before, to say that using an improper appraisal and the value to value the amount of the annuity payments causes the qualified interest to be equal to not qualified interest and valued at zero. So a huge gift was made when the GRAT was created. Okay, I understand the IRS concern, and Lou, let me just pitch it to you at that point.
Okay, well, Steve, I don't want to be the practitioner calling the client indicating that the client's made a 100% taxable gift. And I look at these CCAs, and I think the sole purpose of them is to terrify me. And this one definitely terrifies me. It feels like the old revenue ruling 79-353, which when it came out seemed absolutely incorrect. That revenue ruling said that a ability of a grantor to remove a corporate trustee and replace that corporate trustee with another corporate trustee was a retained right to designate the assets under 2036A1 or A2 rather. And that revenue ruling sat out there and also terrified me and other practitioners for a long time until ultimately the Wall case invalidated it essentially. And then the IRS was forced to revoke that revenue ruling. I think ultimately this case gets to a court, not this case, this CCA gets to a court if they take this position, and I think a court invalidates it. We don't want to be there, right? So if we don't want to be there, what is it we're going to do knowing that CCA is out there and that an audit could theoretically invoke the reasoning in the CCA, i.e., if we violate the facts, we have a 100% taxable gift with a GRAT. Well, number one, the global for all of us is let's stop getting too cute with transactions. Let's go back to the trite phrase and recognize that pigs get larger and hogs get slaughtered. And the fact pattern in the CCA is definitely a hog fact pattern. We don't want to be there. So when you have difficult to value assets, and in particular, let's just talk about GRATs, although the reasoning of this CCA could apply to WANDRE formulas in sales as well and WANDRE formulas in gifts. But let's say we have GRATs. When you have difficult to value assets and you may have a corporate transaction that's going to occur after the GRAT setup, at a minimum, have your valuation as of the date of the GRAT. That is, have the valuation be that date. It can be done after the GRAT's in place, but have it be that date based on facts and knowledge that existed on that date. Facts and knowledge in this CCA would include the understanding that there have been some offers out there. Have your valuation expert take that into account. Do not ignore that. And if you can take that step, you can essentially avoid the concept and the reasoning in the CCA. So we have to be, again, a little less cute with some of the valuations that are going on and a little more timely in terms of the valuation itself. This valuation in this CCA was done months before the actual GRAT was put in place, and that's the one that was used. So that's my major takeaway from this. And again, we're going to have to see ultimately what the court would do if this reasoning is applied to future GRATs or sales. Steve, you want to add to that, please?
Lou, I agree that the CCAs typically come about in an actual case, and the agent will submit an issue to the Chief Counsel Office of what position to take. And so hopefully this actual case will come to a different conclusion. The concern of this case is that it basically puts all GRATs involving hard-to-value assets at risk. If you use an appraisal that ends up being the wrong value, do you risk that the full amount transferred to the GRAT is a gift? The whole point of the major advantage of GRATs is that we can shift future appreciation but not make a huge gift up front. Well, that just puts every GRAT involving a hard-to-value asset under the rationale of this CCA at risk of having a large gift. And it is just totally egregious, particularly in light of the fact that the regulations not only allow us to define the annuity amount in terms of the finally determined gift tax value going in, but it also has a provision that the instrument can say that in the event of an incorrect determination of the value, this is what you do after the fact. And so the IRS approach of saying that it's using the Atkinson case to say it just totally blows up the GRAT and the full gift amount going in is just really an outrageous position. And I agree that I certainly hope the case doesn't go that way. But I certainly also agree with Lou. You have very good ideas on steps to take so that we don't have the IRS viewing our situation as an abusive cheater sort of situation and not to take this sort of position. But very surprising result from this CCA and troubling in the event that it should be upheld by the courts.
Completely agree.
Thank you, Steve and Lou, for discussing this recently issued IRS ruling and its effect on the administration of GRATs holding hard-to-value assets.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review. Follow us on Facebook and Twitter at ACTEC Talk.